car crash cases, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you. Your tough legal questions answered by our experts. The attorneys, with Josh Wright from the law firm of Hollis Wright and host David Lamb.
Good evening and welcome into the attorneys. We appreciate you being with us tonight. For the next half hour, we have a panel of experts assembled ready to deal with a topic that we think is of interest to you all. And here's the way it works best. At the bottom of your screen, you'll see ways that you can get in touch with us, take advantage of that. And the neat thing that Hollis Wright makes available each and every Sunday evening is attorneys are standing by live for the duration of the show. That conversation is off the air, confidential, and doesn't really even have to do with our topic tonight. So the opportunity to get some great free legal advice there. Take advantage, just pick up the phone and give them a call. Now, leading our conversation here from the firm of Hollis Wright, one of the partners, Carter Clay. Carter, good to see you, sir.
Good to see you, David. I hope you're doing well.
Doing well. Thank you, sir.
Great. Yeah, tonight we're going to be talking about estate planning. We're going to be providing the viewers some tips and tools to account for that inevitable event when you or a loved one will pass away. And I always tell people, this is a show that applies to every single person out there unless you figured out a way not to die.
And most folks are in denial about it, but yes, we are all one day.
That's right. And it may not be the most exciting topic, but it is a very relevant and material topic to each and every person that is out there. And not only are we going to be talking about wills, which everybody generally knows what a will is, but we're also going to be talking about some other very important documents that people can create outside the will. Even if they don't have a will, they can create these documents that will help in various circumstances in their lives. And really, this is a very important topic and really something that people really need to pay attention to, because the majority of people out there are walking around without a will or without any estate planning documents in place. And it really can create problems and wreak havoc on the heirs and your loved ones when you pass away or when you get into a medical condition, perhaps, where you can't make your decisions. And so really making these types of decisions on the forefront will help protect you, will help protect your assets, and more importantly, will give you peace of mind in knowing that your loved ones will not be stressed out in the event that you die or you get into a situation where you can't make decisions for yourself. So that's really what we're going to be tackling here tonight. We're very fortunate to have Kayla Schoen on with us. Kayla clerked with us several years ago.
That's right.
Then she got out of law school, passed the bar exam, and she's been out on her own pretty much ever since and has developed a very good niche with estate planning, doing wills, drafting various estate planning documents, and she's doing an excellent job for her clients. And so we're very thankful to have you on the show here tonight, Kayla.
Thank you. Yeah, this is my third time on the show, and I'm just as excited today as I was the first time, so thank you.
Well, you're welcome. Well, tell the viewers a little bit about your legal practice and kind of where you specialize.
So really, I specialize in estate planning and probate work, which in Jefferson County, the probate court handles a variety of different kinds of matters, but the bulk of it would be the administration of estate. So whether someone passes with or without a will, they handle those matters. Yeah.
Now, of course, I'm sure you get this type of comment a lot, because we get it a lot as well, which is, well, I don't need a will because I'm a person of little means. I don't have anything to give away to my heirs if I die, so why do I need a will? And what is your typical response to people that make that kind of comment?
Yeah, that's a really common comment. There actually is a Small Claims Estate Act that's in place. If your estate is roughly around $28,000 or less, you can still administer your estate, and it can actually be done a lot faster than the law typically requires. And so in addition to that, there are other important aspects of having a simple will, which is really inexpensive, more inexpensive than I think most people think it is. You know, if you have a minor child, a will is the only way that you can name a guardian for that child or children. Otherwise, the court will decide upon your death who would be a guardian, and it may be somebody that you'd be thrilled to take your children that you would have wanted, but it may not. And so there's certain things like that. If you have a passion for a certain charity, I have a lot of people that have pets, and they put that in their will, that they want to make sure, if they pass and their pet is still alive, they want the pet to go to someone. And so there's just an endless amount of things you can list in your will to be tailor-made to what you would want.
Now, I have talked to other estate planning attorneys, and they tell me they want people to know that you may not have actually drafted your own customized will, but if you haven't done that, you still have a will. It's just the will is done by the state of Alabama.
Sure.
I mean, it's not called a will, but it still functions as a will, but the property and the assets would be distributed in a way that the state sets forth. Is that right?
That's right. So let's say, for instance, I am just a single individual, and I have maybe total with property and everything $1 million worth of assets, and I pass away. The laws of the state of Alabama provide a certain sort of hierarchy of how my assets would be distributed. And so it would be called an intestate estate. I don't have a will. And so first it would go to my surviving spouse if I had one. Well, I don't. Well, then it would go to my children in equal shares if I had them. Well, I don't. So then it would go to my parents, which I do have. And so they have certain hierarchy. Again, it would go, if you didn't have parents, it would go to your siblings, and so on and on and on and on. And so again, it's important to have a will, even just a very simple will, in the event that, you want to be able to be specific about where you want your assets to go.
Yeah, and I think the main distinction that people need to understand is that by drafting your own will, you are controlling where any assets or money go at the time that you pass away, whereas if you don't have a will, the state controls it, and honestly, you may wind up in a situation where somebody down the chain winds up getting your assets and money who you don't particularly care for, but that's what the state says has to happen.
Sure, and another thing that, people consider is wanting to give their beneficiaries of their estate certain assets for certain reasons. So for instance, I've drafted wills or trusts for clients who want to make sure that their siblings go on a family vacation every year, because it's very important to them that their children stay close. And so they may put it in their will that X amount of money every year, is given to the beneficiaries for the purpose of, going to Gulf Shores for 1 week at this, location or whatever, so that they can all stay together. And so, you can really get as specific as you really want.
Now, can you also go on the other end of the spectrum and do it in a very general sense? In other words, there might be individuals out there that say, I don't have any assets, therefore I don't need to have a will, but you can actually draft a will in a very general fashion that will account for you actually getting assets in the future. In other words, you could state in there that any personal property that I get will go to John Doe.
That's right, yes. So the law in Alabama states that if you're in possession of somebody's will, you have to submit it to probate within 5 years of the person's death. But there is no limit on when you can close the estate. And so, yeah, if property keeps coming in, it can stay open for those purposes.
Let's step aside for our first break of the evening. All right.
It's already flying by.
Now's a good time. That's
Yeah.
right. You guys are doing great. As we head to break, a reminder of how you can find the firm of Hollis Wright on Facebook as well as Twitter. A really informational, educational resource. You're going to want to follow them there. Stay tuned. We've got more of the attorneys coming right up.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm. Thank you for watching The Attorneys. Now, we hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple. Provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to the show or related to other accident or injury-related topics, you can call, email, or text us. Or you can also follow us on Facebook or Twitter, or simply contact us by going to hollis-wright.com and click on the Contact Us link. We know your time is valuable, so thank you for spending it with us watching The Attorneys.
I could use that digital legacy whenever I forget my password.
That's right.
That could really be helpful. Welcome back in to The Attorneys. Thanks so much for being with us tonight. A reminder before we get back into the conversation with Kayla and Carter is that attorneys are standing by live from Hollis Wright right now. So if you have a question about estates and probate, what they're talking about tonight, or any other matter, take advantage of that opportunity. Just pick up the phone and give them a call. Carter?
Yeah, Kayla, I said at the outset that we were going to talk about some other important documents from an estate planning standpoint that people need to consider drafting aside from wills. And to this point, we've talked a lot about wills, and I'm sure we'll circle back to some additional aspects regarding wills. But I want to talk about some other documents that people need to be aware of out there, that even if they don't have a will, these documents could be very important to them in their personal lives and very important to their day-to-day affairs. So let's talk a little bit about that. What other types of estate planning documents or tools are available to people to account for those types of events?
Sure. So one thing to keep in mind is a will only takes effect when you pass away. And so there are other estate planning documents that will take care of certain things when you're still living. One of them would be a power of attorney. And so that would be a document that would list an agent who's able to act on your behalf in the event that you become incapacitated, and they can handle your assets, things of that nature. Another very important document is what's called an advance directive of health care, and it basically lists out what you would want done as far as your health care in the event that you become incapacitated and can't make those decisions for yourself. It relieves your family of a lot of burden of having to guess what you would want done. It's not as simple as a DNR. It is very specific. Do you want a feeding tube? Do you want, respiratory help for a certain amount of time? I mean, it's very, very detailed. You can literally just initial by each choice, have it witnessed and signed, and then turn it over to your physician, have it in your medical files. And according to the law state of Alabama, hospitals and physicians have to follow your medical directive. And if they are not willing to do that, they have to transfer you somewhere where somebody will follow those. And again, your family may not have wanted to do certain things that you want, but at least they have the peace of mind of knowing that they're doing what you would want.
Yeah, and then I think the third component that we were going to talk about is the revocable living trust. Is that right?
Sure. That's not as common, but it is an option as far as transferring assets into a trust that you can manage during your lifetime. A lot of times your spouse or your children will be the beneficiaries of that trust, and it is a way to avoid probate, which means that any property that goes into the trust is sort of private. If you submit something to probate in a will, it becomes a public record. And so if you do it through a trust, it can be kept privately. It also has some estate tax benefits if you do it the right way. And so a lot of people ask about having one of those.
Let's talk a little bit about each one of those in a little bit more detail. I've got some questions about the power of attorney. As I understand it, there are essentially two forms of powers of attorney. There's a traditional power of attorney, and then there is a durable power of attorney. Which of those do you recommend now, and what are the differences between the two exactly?
So a traditional power of attorney would stop as soon as you become incapacitated or you pass away, whereas a durable power of attorney would continue during any sort of incapacitation. If you're in an accident, you're in a coma, and somebody needs to, you know, pay your mortgage, pay your bills, make certain decisions if you're, you know, business partners or whatever. And so most people go for the durable power of attorney because of those reasons.
Now, mechanically and procedurally, how do these powers of attorney work exactly? So if I came to you and you drafted a durable power of attorney where I appointed, say, my children or somebody else to have power of attorney to handle my day-to-day affairs, how do the bank, if they can go in and get money out of my bank account, am I supposed to give the bank a copy of the power of attorney, or does the person who has power of attorney do that? And what if I wanted to revoke the power of attorney at some point in the future? How is that communicated to the bank or to any businesses out there that, hey, at once I gave this person the authority to do this, but now I'm revoking it and I don't want them to have the authority anymore? It seems like that could get really confusing and hard to track, but how does all that work?
Sure, so I always recommend to my clients, you know, maintain the original copy, or I can maintain it. If they want to, I can hold on to it. Obviously keep copies, and whoever you appoint should have a copy and should know where it is, or if you want to just keep the original, let them know where it is. You can revoke it, like you said, at any time. You can tear it up, burn it, sign something saying you revoke it, and so as long as you're, you know, incapacity to do that, you can revoke it, change it, amend it. But yeah, I always suggest to people to, you know, you let somebody know, hey, I want you to be my power of attorney. Are you okay with this? This is what's involved with it. Make sure they're on board, and to, you know, like I said, make sure, you know, if you just want to have the original or copy in a safety deposit box, and, you know, let them know where that is. And, you know, kind of keep them apprised of that. And that's why people that you choose should be people that you think carefully about, because if you do change your mind, you want to be able to go to them and say, change my mind, I'm doing something different.
Yeah. Yeah. All right. Hey, time for our second break of the evening. We're going to step aside. We're coming right back. More with Kayla and Carter. That sounds like a morning show, doesn't it? Kayla and Carter.
Thanks for the promotion.
Yeah, we'll do it.
That's a new idea. Yeah, we'll be back. Their conversation continues as we head to break. Here's how you can join our conversation. A few minutes to do so, so take advantage of that. Stay tuned. More of the attorneys with Kayla and Carter coming right up.
I'm attorney Bobby Bell with Hollis Wright Law Firm. In today's world, social media is all around us. It is common for many people to post on social media regarding their life and activities on a daily basis. Facebook, Instagram, Twitter, and similar social media are a great way to stay connected to others and to share your experiences and thoughts. Some seemingly innocent social media posts, however, can have devastating effects if you're involved in litigation, especially in a personal injury claim, a contested divorce, or a child custody battle. Courts regularly allow adverse parties access to the other side's social media accounts, allowing relevant posts to be presented as evidence. These rules have allowed social media to become a hotbed of information in the litigation world. In fact, we are seeing more and more preservation orders issued by courts requiring you to collect and save any and all social media activity. Therefore, it's advisable that even before there's litigation, lawyers should advise their clients that social media content may be discoverable. Here are a few helpful tips. 1. Do not post anything about the case. This includes posts regarding conversations or meetings with your attorneys, remarks about your injuries, negative remarks about the opposing party. Do not post anything you would not want read in open court to either a judge or a jury. 2. Avoid new friend requests from people you do not know. Many law firms and insurance offices may attempt to have employees follow you on social media in an attempt to gain information. 3. Limit adding new photos, check-ins, photo tagging, etc. Seemingly innocent posts may be used against you. Regular check-ins at restaurants, parties, or other events with friends can cast doubt on any claims of loss of enjoyment of life, pain and suffering, or emotional distress, since you appear to be living life as usual. 4. Increase your privacy settings. Many social media sites frequently update and change their privacy settings. In the litigation context, it is possible you may have to preserve and present anything you posted. Therefore, we encourage you to be smart and careful when using social media. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. Remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you. Thanks for watching The Attorneys on WBTM 13.
Well, a sad little firm fact right there, huh? Yeah. Welcome back in to The Attorneys, talking about matters of adoption and probate and estates, kind of covering all kinds of territory tonight. Just a few minutes remaining, about 8 minutes remaining in the show, so if you want to take advantage of the opportunity to speak with attorneys standing by live or just to get a question in to us, you got just a few minutes remaining, so take advantage of that. Carter?
Yeah, Kayla, I want to come back and talk a minute about the Advanced Healthcare Directive document that you mentioned a minute ago.
Sure.
And as I understand it, that's really a document that you can create to account for an unfortunate situation where perhaps you're injured catastrophically in an accident and maybe you're in a coma or on a ventilator, or perhaps just you're up in age and you become incapacitated and not able to make your own medical decisions. Is that right?
That's right, yeah. I suggest to people, and it's like most estate planning topics, nobody wants to think about it, nobody wants to talk about it because you don't want it to happen, and most times it won't. You're planning for these, tragic accidents, but you're planning ahead like you do for everything else. That's why you pay insurance on your house, your car. And so, the Advanced Healthcare Directive is something that you do when you're well, when you're of sound mind, and you know exactly what you want. You put it in writing, you let your family know, you name healthcare proxy, which is the person that will carry things out for you according to what you've said, and I always have my clients name a backup in the event that something happens to the first choice, they don't want to do it or they can't do it for some reason. And I always suggest that it be a primary and a secondary. When you do a joint proxy, you can, but that again can lead to issues with those two people have to agree.
Okay.
And so sometimes it's better to just have one person to avoid, any potential conflict.
Yeah, when you talk about a healthcare proxy, you're just talking about a spouse or a family member perhaps that they're appointing in the document that in the event the person gets in this type of catastrophic condition, they're on a ventilator, they're in a coma, those people will make the decision to carry out the wishes of the person.
That's right. You list in the healthcare directive what you want done, but it can't list every possible, aspect. It can't cover everything. And so basically you're saying, I want this, 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 and this. But if I haven't said specifically what I want, something happens, this proxy, I give them permission to make decisions, about my health care.
Now, I've seen this in television shows and I've also seen it in real life. Can the proxy go against the wishes of the documentation? In other words, person's on a ventilator, spouse is the proxy, and spouse just can't bring herself to make the decision to take her husband off the ventilator. Can they override it or do they have to follow it?
You can put that in there.
Okay.
You can tailor it again to say if they think differently is in my best interest, but if not, then no.
Whenever I could just hear people kind of ka-ching, ka-ching kind of going off in their minds, talking about wills and durable power of attorney and all that sort of thing. Folks kind of usually go to the bottom line of cost. How do the costs relative to these matters work out?
So it really does vary from person to person, firm to firm, case to case, how specific you want your documents, how complicated they are. you know, what you want. Do you just want a simple will? Is it just you? You're an unmarried individual, no minor children, and very little assets. You know, for me, a couple $100. But then if you're a married couple with minor children, there's additional language in the will. You also want a power of attorney. You also want an advance directive. You know, each spouse has to have one. You can't do it jointly. So the costs go up in, you know, the $1,000 range. Of course, I've heard of people being charged a lot more. But again, it's case to case, and depending on and what you want.
It depends a lot on the complexities of the situation. Like she said, married, children, how much money do you have, what are the assets that you're disposing of. But you will do these, and other lawyers will do these on an individual basis. In other words, you'll just do an advanced healthcare directive, or you can just do a durable power of attorney. It's not like if somebody comes to you, they've got to get all this stuff done.
No, and that's not uncommon. I have had young, very newly married couples with no kids. Maybe they just bought a house, and they'll go ahead and get both a will, power of attorney, healthcare directive. Some will do one at a time. Let's just go ahead and do a will. They'll do something later, and that's not uncommon. No.
And I think it's also
just about 2.5 minutes left.
Okay, I think it's also important for people to know that not every asset out there is going to be disposed of through the probate process. For instance, life insurance, if I'm correct, you designate a beneficiary. That life insurance benefit is not going to flow into the estate. It will be handled outside the estate.
That's right. Anything that would be considered a contract. So a life insurance policy, a retirement policy, bank accounts can be made payable on death. All of those, you should have a beneficiary, a backup beneficiary, and they pass outside of probate. That's not in the will, so that's separate, yes.
We're just about out of time. Believe it or not, a couple of minutes remaining, but time enough for a final thought from the both of you. And Kayla, if you would, you go first. Please.
Yeah, sure. I would just tell people, you know, you don't always need to have estate planning documents drafted right away, but you might just want to meet with a financial advisor or an estate planning attorney and just talk about what your options would be based on your assets now, based on your future goals. And a lot of times I have clients who have had estate planning documents drafted several years back. Different, you know, federal or state laws have passed that may change certain things, and so you might just want to have it reviewed to make sure it's still up to date. Okay. So simple things like that.
Yeah, I think what I would say, and David, you know, we do the phone banks, and we get a lot of calls during the phone bank, and I think there's a big misconception out there about lawyers, because all of the lawyers that I know are willing to talk with anybody about a topic that they're comfortable talking about for 5 or 10 minutes. Right. But a lot of people think, I'm not going to call the lawyer because they're going to immediately charge me. And in this particular area of law and in personal injury, which is what we handle, pick up the phone and call Kayla. She'll be happy to talk for 5 or 10 minutes to at least identify those areas that you may really need some documentation from an estate planning standpoint.
Yeah, it could save you a lot of time, heartache, and money as well. Hey, thanks to both of you for being with us tonight. Kayla, good to see you once again. Carter, appreciate it. We also really appreciate you being with us each and every Sunday evening. We'll look for you next time. Thanks again for being with us. We'll see you next time on The Attorneys.
Thanks for watching The Attorneys, sponsored by Hollis Wright.